Good morning, distinguished delegates. We trust that everyone had an enjoyable evening last night in New York, and we shall now resume our work. This morning, we will resume our meeting in plenary for oral reports on the discussions held yesterday afternoon under item 5 of the agenda entitled Consideration of the Matters to be Addressed by the Conference of the Parties to the Agreement at its first meeting and additional matters as identified by the Preparatory Commission. Afterwards, we will continue our consideration of the issue arrangements for the functioning of the Secretariat, including its seat in Informal Working Group 1. Then, time permitting, we propose to resume the plenary meeting to have, under item 7 of our agenda entitled Other Matters, an exchange of views on the 9th replenishment of the Global Environment Facility Trust with a view to considering the possibility for the PrepCom to provide provisional guidance to the GEF replenishment process, for the interim period until the Conference of the Parties to the Agreement is able to provide such guidance as foreseen in Article 52, Paragraph 9 of the Agreement. Distinguished delegates, we will now provide brief oral reports on the discussions that took place yesterday afternoon under item 5 of the agenda. In this respect, we wish to reiterate that the oral reports are not meant to be an exhaustive and detailed summary of all the views expressed and the proposals made, but rather to provide an idea of the topics that seem to be the focus of delegations' interventions and general trends in the discussions. The reports are, of course, without prejudice to the discussions still to be held at the PrepCom, and all options raised by delegations remain on the table. And with that, I will commence with my oral report regarding the sessions that were held in the main conference room yesterday. Informal Working Group 1 continued to consider the issues of arrangements to enhance cooperation with relevant legal instruments and frameworks and relevant global, regional, sub-regional and sectoral bodies, to be known henceforth as IFBs, and rules of procedure for the Conference of the Parties on the afternoon of 21 August. Turning first to IFBs. Discussions on cooperative arrangements with IFBs were based on a note by the Secretariat and structured around questions 3 and 4 of the guiding questions circulated on 29 July. Following some inputs on these questions in yesterday's morning session, in responding to guiding question 3, delegations made a number of suggestions on what cooperation arrangements and with which IFBs would be necessary in the early operation and implementation of the agreement, and discussed a possible prioritisation of arrangements based on IFB mandates, as well as any possible lessons learned from existing arrangements. In addressing guiding question 4 concerning what key elements of cooperation arrangements will need to be considered by the Conference of the Parties, delegations discussed adaptability, practicality, flexibility, efficiency and effectiveness, equity and inclusiveness, levels of formality, the role of the Conference of the Parties in overseeing cooperation arrangements, the duration of cooperation arrangements, strategies to manage overlapping mandates and avoid duplication, reciprocity, cost effectiveness, and financial implications, and the inclusion of IFBs in the work and processes under the BBNJ agreement. On the possible way forward, the co-chairs proposed that the Preparatory Commission, at its third session, consider a draft decision providing guidance on cooperation with relevant IFBs to be forwarded to the first meeting of the Conference of the Parties for consideration and adoption. Delegations were invited to consider this proposal in advance of the next meeting of the Informal Working Group on Monday, 25 August, in the afternoon session. Delegates, I'm conscious that because we were in parallel sessions yesterday afternoon, a number of delegates will not have directly heard the summation of how we intend Monday afternoon session to work. So let me be very clear on that. We have the proposal that the outcome from this process, and as we have said before, the IFB's item, unlike some others, like for instance, the rules of procedure, does not have a designated endpoint document for passing on to the first conference of the parties. It is open to us to determine what is the format of the product or guidance we will provide to the Conference of Parties. We've put forward a proposal that that product be a draft decision to be considered and hopefully endorsed and adopted by the first Conference of Parties on the principles that will guide the relationship between BBNJ and the IFBs. There will not be another paper produced on this subject between now and the Monday afternoon session. Rather, the Monday session, which will be the last session we consider IFBs at this PrepCom, will have before it two guiding questions. First, is this modality an acceptable end product from the PrepCom process for forwarding to the Conference of the Parties? That modality being the draft decision that I referenced previously. Second, if so, what elements do delegations consider to be important to be included in such a draft decision to be forwarded from this PrepCom process to the first Conference of Parties? Based on the outcome of those discussions, we will then prepare in the intersessional period a draft decision, well, apologies, it will be a draft decision for forwarding from this Preparatory Commission process to the first Conference of Parties, and that draft decision will be considered and hopefully finalised at PrepCom 3. So that is the proposed way forward on this item, and we will put both those questions to the session on IFBs on Monday afternoon. If I can now turn to the rules of procedure for the Conference of the Parties that was also considered yesterday afternoon. Discussions on the rules of procedure for the Conference of the Parties were based on the revised aid to discussions and negotiations prepared by the co-chairs. That's AAC 296/2025/12 and structured around guiding question 3. Delegations continued to discuss the frequency and modalities of meetings of the Conference of the Parties, including modalities for the intersessional decision-making on emergency measures under Article 24 of the agreement. Delegations also considered notification periods and the modalities for the circulation of documents. With regard to observers, delegations continued to discuss how to balance the agreement's requirements for transparency, inclusivity, and the role of IFBs with possible accreditation procedures. Delegations further expressed views on the Bureau, its officers, and its relationship with the President of the Conference of the Parties, as well as on the support that the Secretariat could provide to the rapporteur. With regard to the conduct of business and decision-making, delegations expressed views on quorum and on decision-making procedures, including the modalities of voting, the possibility of secret ballots, language on voting by regional economic integration organisations, the possibility of proxy voting, and decision-making modalities of subsidiary bodies. Regarding amendment of the rules of procedure, delegations continued to discuss the appropriate procedure and threshold for decision-making on such amendments. Finally, delegations considered the extent to which the rules of procedure should reflect certain articles of the agreement, including Articles 6 and 18, as well as provisions regarding consultations, cooperation, coordination and/or collaboration with, and not the undermining of, relevant IFBs. On the way forward, as previously announced, the co-chairs will prepare a refreshed text on rules of procedure for the Conference of the Parties over the weekend for the consideration by the Preparatory Commission next week. In that regard, I would just note that we got reasonably close to, but did not exhaust our list of speakers on that item yesterday. So it would be our hope that at some stage today, depending on how the three sessions that we have today proceed, that there might be an opportunity to put that item on and conclude our list of speakers in order to facilitate the process of providing a revised text for next week. So we will be very grateful for the cooperation of delegations in remaining flexible and being prepared to return that item at some point over either this morning's session or one of the two sessions this afternoon. And with that, that concludes the summation of yesterday's proceedings in Conference Room 4, and I now give the floor to Janine.
Thank you, Adam, and good morning to everyone. Informal Working Group 2 considered the issue of modalities for the operation of the clearinghouse mechanism in the afternoon of 21 August. After concluding the list of speakers in the informal working group format, an informal meeting was convened to advance text-based negotiations, which completed a first reading of the draft terms of reference for an informal group on the technical aspects of the operationalization of the clearinghouse mechanism as contained in document A/AC 296/2025/15. While some terminology issues still need to be addressed to ensure clarity and unity of understanding, the objectives of delegations with respect to the document appear to be largely aligned. With regard to the tasks of the group, there seemed to be broad agreement with respect to the three tasks listed in paragraph 2A of the draft, as well as on an additional task regarding the review of existing clearinghouse mechanisms and information exchange platforms. Further consideration will be required on another proposed task relating to possible interim arrangements to provide certain functions of the clearinghouse mechanism upon the entry into force of the agreement. Further consideration will also be required on the size and composition of the group, and I encourage further discussions among the different proponents. We will also need to further consider the process for the nomination of experts and return to the question on the appointment of the co-facilitators of the group once the overall size of the group has been resolved. With regard to working methods, there appeared to be general agreement on the draft text with some adjustments proposed. Further consideration will be needed on the level of guidance that would be desirable to provide to the group. In terms of the way forward, the co-chairs consider it beneficial to entrust further discussions at this session on the size and composition of the group to a focus group with a view to that group reporting back to the next informal meeting. And for purposes of having that focus group, we will be identifying co-facilitators to conduct the discussions in that focus group. And we'll be sure to communicate names as soon as possible. We encourage interested delegations to participate in that group, as well as consult bilaterally with a view to swiftly identifying an optimal size and composition for the group that would serve its objectives while also ensuring inclusivity. And with that, I conclude my oral report. Thank you.
Thank you, Janine. The floor is now open for comments on the reports just made, bearing in mind that they are not meant to be an exhaustive reflection of all of the views and proposals raised, but rather to identify the main issues that have been the focus of delegations' interventions and the way forward. I see no one wishing to take the floor, so we will now adjourn the plenary meeting to resume our work in the format of Informal Working Group 1 on governance issues to consider our consideration of arrangements for the functioning of the Secretariat, including its seat under item 5 of the agenda, and I will now hand the microphone to Janine.
Thank you. Distinguished delegates, to guide our discussion this morning on this issue, my co-chair and I have prepared a document entitled Overview of Proposed Elements for Arrangements on the Functioning of the Secretariat, which was circulated by the Secretariat last night. This document was informed by the discussion earlier this week and outlines proposed elements distilled from the discussions in relation to arrangements for the functioning of the Secretariat, in particular institutional arrangements. In this respect, we wish to emphasize that the elements contained in the document are not intended to be exhaustive and are without prejudice to any other options on the table. We also note that the document does not address aspects pertaining to the selection of the seat of the Secretariat. On this particular matter, my co-chair and I propose resuming our discussion this afternoon in the format of informal informals with a view to exploring the most appropriate way forward in considering the issue of the seat. So the floor is now open for comments, but I would like to provide two questions to help guide your reflections on the elements. We would suggest that you may wish to, in your comments, reflect on what output or document would be useful for delegations to progress work or arrangements for the functioning of the Secretariat that could be prepared by the co-chairs during the intersessional period. And two, is the list useful to identify relevant elements that could inform that text? The floor is open. I see Palau speaking on behalf of the Alliance of Small Island States.
Very good morning, co-chairs. Good morning, colleagues. I am speaking on behalf of the Alliance of Small Island States, and we hope to help think through the way forward and are keen to hear from others as well. We thank you for the overview of proposed elements for arrangements for the functioning of the Secretariat, which, as you've noted, captures some of the elements shared this week. We see it as a non-exhaustive list, and we know that it is missing some elements which we will raise. We also know that some elements listed may not be compatible with each other. Excuse me. AOSIS has been keenly listening to the deliberation of colleagues, and we observe a spectrum of options emerging. An option A, a standalone institution. An option B, a hybrid model that has some linkages to the UN, such as the UNFCCC model. An option C, a UNEP type setup. And option D, a full integration within the UN system. It may be beneficial for the COP to have a document that sets out these options for their selection. The Alliance of Small Island States would be keen to hear from colleagues who supported the UNFCCC model, whether they would like all the linkages that the UNFCCC has to the UN replicated here. Now, that takes us to the second point about the selection of the head. Again, we see two options that could be reflected in a document. One, wholly selected by the parties, or two, as with the UNFCCC model, where the head is appointed by the UN Secretary General in consultation with the Bureau. We see these as two options, and perhaps colleagues see others, but we see these as two options that could be reflected for the COP to decide. That said, AOSIS still needs some advice, perhaps from the UNSG's office, on the following. If parties elect the head, can they still benefit from all, can the head still benefit from all the privileges and immunities of the UN, given that the UNSG would have no way of dealing with any violations, as the head would be reporting solely to the parties and would be in contract with the BBNJ Secretariat? We would be grateful for some advice and clarity to make sure that we're providing the COP with actual possibilities that are in fact possible. In the same document, we could also include elements of the Secretariat's characteristic. As AOSIS has previously indicated, our preference is a mid-sized Secretariat, includes a dedicated SITS unit, multidisciplinary staff to address the breadth of work required. We reiterate that the BBNJ Secretariat must prioritize recruiting staff on a wide geographical basis, as wide a geographical basis as possible, ensuring equitable representation. Madam Co-Chair, this could be one document. In a separate document, we envision the beginning of an agreement between the BBNJ Secretariat and the UN. Once the model is selected, and if there are any linkages with the UN, the COP can promptly consider the content of an agreement that, as you know, Co-Chairs, AOSIS sees including the possible following elements: cooperation and coordination, reciprocal representation. On conference room services, we see this, but we see mostly value in using it for document services. So we see the benefit from interpretation support of 6 languages of the UN, but we would opt for our own conference room offices. The laissez-passer, as well as internal and external audit processes, which of course we've already mentioned, we are considering the cost-benefit implications of that. We can already draw on existing agreements as the language is somewhat boilerplate, but here again, it should be reflected as options. No linkages, or option B with the following linkages and what those are. And then everything, the document as a whole, could be placed in square brackets so we can accommodate for those who do not think there should be any linkage at all. In short, we propose creating 2 documents: 1, potential options for the Secretariat model, and 2, potential content for the BBNJ Secretariat agreement with the UN. Thank you, Co-Chair.
I wish to thank Palau on behalf of the speaking on behalf of the Alliance of Small Island States, and Palau is the only speaker on the list. So we've heard their proposal on potential next steps. If anyone wishes to react, the floor is yours. The European Union has the floor.
Thank you very much, Madam Co-Chair, and good morning to all. It's great to see you here on a morning where the sun is finally shining in New York. So that's good for the mood, I hope, today. I have the honor of delivering this statement on behalf of the EU and its 27 member states. At the outset, we would like to express our sincere appreciation to the Douala Secretariat and the co-chairs for the document overview of proposed elements for arrangements for the functioning of the Secretariat. We believe that this document provides a helpful synthesis of the commonalities emerging from our earlier discussions this week. We are pleased to note that many of the elements the EU and its member states consider important for the BBNJ Secretariat are reflected in this document. We will structure our intervention today by offering reflections on the elements, presenting in each of the sections of the document. We will then share suggestions on how we believe the preparations for the functioning of the Secretariat could move forward. We will start with section 1 on institutional arrangements. As mentioned in our earlier intervention, the EU and its 27 member states envisage a Secretariat that is operationally independent, institutionally strong, and internationally visible. It should act transparently and should operate under best practices for institutional governance. The Secretariat should be subject to oversight by the COP, with additional accountability through institutional linkages to the UN, with the head of the Secretariat also accountable to the UN Secretary General. We therefore agree with the principles listed in the first bullet of the document. We are very conscious that we are rapidly approaching the 60 ratifications required for the BBNJ agreement to enter into force. Therefore, we also consider that it is important that the model of secretariat chosen enables it to be established without undue delay in a manner that will facilitate the smooth transition of the functions currently undertaken by Dualos on an interim basis. Turning to bullet point 3 on the degree of institutional linkage to the UN, this is a critical issue and one which the EU and its member states believe that the PrepCom must address. We would like to emphasize the importance of applying the UN Convention on Privileges and Immunities, the UN Staff Regulations, the UN Financial Regulations, and for the Secretariat to be subject to the oversight of UN audit mechanisms. We also consider it important for the PrepCom to lay the groundwork to give effect to these institutional linkages. We suggest that the PrepCom could do so by preparing a letter to the UN Secretary General that sets out the elements of institutional linkage that PrepCom envisages the Secretariat will have. We suggest that such a letter to the UN Secretary General would request that he advises the PrepCom on an institutional arrangement for the Secretariat, which would ensure that it is institutionally linked to the UN and follows the following list. And I'm going to apologize beforehand because the list is quite long. To be cost effective, economical and financially sound, ensure efficient administrative support from a United Nations department at the lowest possible cost in a manner that would allow for adequate managerial autonomy and flexibility, as well as for the accountability of the head of the permanent secretariat to the Conference of the Parties. Ensure that the Secretariat enjoys international legal personality. Also ensure that the UN Privileges and Immunities Convention applies. Ensure that the UN Staff Regulations also apply. Ensure that the UN Financial Regulations and the UN audit mechanisms apply. Ensure that the Secretariat is outside the framework of any existing UN institution or program, thereby providing for the autonomy, responsiveness, and accountability of its Secretariat. Ensure that the Secretariat will respond to policy guidance from the COP, and its head will be accountable to the COP for the implementation of mandated activities and for the use of money contributed by the parties. Ensure that the arrangement facilitates the mobilization by the Secretariat of the full range of scientific, technical, and specialist expertise required by the agreement, in particular to support the work of the specialized subsidiary bodies established under the BBNJ agreement. And finally, thank you very much all for your patience, enable the head of that Secretariat to promote collaboration and synergy between relevant UN bodies and Secretariat of other IFBs. We're also, of course, very much open to having discussions on this with others. The EU and its member states envisage that the general principles of the Secretariat's linkage to the UN could thereafter be recorded in reciprocal decisions of the BBNJ COP and the UN General Assembly. Finally, on this section, the EU and its 27 member states want to ensure that the Secretariat is fit for purpose. In our view, the inclusion of a periodic review mechanism will be an important safeguard to enable the regular consideration by the parties of its functioning. Then on section 2, with the size and structure. The EU and its member states agree with the African group, with Japan and others, that the BBNJ Secretariat should be scalable, immediately operational, and that it should operate in a cost-effective and efficient manner. In our view, we should not be overly prescriptive as to the structure of the Secretariat at this stage, including by listing various units. This matter should be left to the head of the Secretariat. On section 3, with the privileges and immunities, we wish to refer to section 1, where we already highlighted the application of the UN Convention on Privileges and Immunities. On section 4, on the legal status of the Secretariat, the EU and its member states wish to emphasize the importance of enabling the Secretariat to have international legal personality, as we've also done so in previous interventions. Then on section 5, and sorry, we're going through it quite staccato, but we believe that this might be the easiest also for the co-chairs and the secretariat to take into account our comments made. On the head of the secretariat, the EU and its member states wish to reiterate that the appointment process should be rigorous, open, transparent, and inclusive process, with due regard given to equal and fair geographical distribution, through rotation and taking into account gender balance of suitably qualified candidates. Furthermore, we consider it good practice for candidates to outline in writing their vision for effectively advancing the work of the BBNJ Secretariat and their priorities for action to progress the goals of the agreement. We also consider that in the appointment of the head of the BBNJ Secretariat, significant weight should be given to the qualifications, the competences, and experiences of candidates. In view of ensuring the Secretariat is rapidly set up and that it can commence its function swiftly, we could also consider starting the process to identify possible candidates for the head of the Secretariat. Then on section 6, the staff selection, the head of the Secretariat would administer the staff of the Secretariat in accordance with the United Nations staff regulations and rules, and such special rules as may be established by the head of the Secretariat in agreement with the Secretary General of the United Nations. Co-chair, to make our lives a bit easier and to summarize the following, there are 3 points that we would like to emphasize. In our view, the Secretariat should strive to ensure cost effectiveness, economies and financial efficiencies in the organization of conferences of the parties through the use of conference services provided by the UN. Second, an efficient arrangement for administrative support to the Secretariat would ensure proper procedures, controls, and accountability, while allowing for managerial autonomy, flexibility, and accountability to the COP. Should the institutional arrangement outlined above be considered satisfactory by the PrepCom, a draft decision covering the different aspects of the arrangement, including the understanding among collaborating departments and programs, could be considered by the COP. Thank you very much for your patience, and we are very much looking forward to continue these discussions this afternoon, but also next week.
Thank you, European Union. And whilst you were very diligent in outlining all of these points, I may have missed the timeline you had suggested for the letter and the expected response to the letter that you indicated in the first part of your statement. So if you could clarify, you can do it after, okay. In the meantime, I'll go over to South Africa, speaking on behalf of the African group.
Thank you, Madam Co-Chair, and good morning, colleagues. Madam Co-Chair, the Africa Group would like to table preliminary reflections on the paper that was shared last night that has been prepared so accurately by the co-chairs. We would like to point out that in our view, the paper is a true reflection of the proposals that have been tabled in the meetings that we've had so far. However, we would also want to point out that there's few elements that we would have wished to see reflected on the document, having it in mind that it's not meant to be an exhaustive list of all the issues to be discussed. We have noted with appreciation that a number of the African group's proposals have been captured in the document that has been prepared by the co-chairs. This includes the principles that should underpin the Secretariat, the minimum threshold of immunities and privileges of the Secretariat, its staff, and their dependents and representatives, the legal personality of the Secretariat that is lean at first, but with the possibility to grow, facilitating unimpeded access through, for example, visas. Those are the issues that the African Group has proposed, and we are pleased to have seen their reflection on the document. Importantly, we've also noted that some aspects have not been captured, and although I've already stated that we we note that the document is not an exhaustive list. We feel that it is extremely important that we highlight the issues or the points that the African group would have wanted to see reflected in the document for possible inclusion in a revised document that may come later on. These issues include the issue relating to budget to ensure the robust and sustainable secretariat, the ability to administer various units, including the clearinghouse mechanism, explicit inclusion of host state infrastructure requirements, which would cover health, safety, and connectivity as part of the headquarters agreement. And also a site inspection procedures to ensure readiness before the seat is finalized. We view these issues as extremely important for our group so that we ensure that we make an informed decision when it comes to the seat of the Secretariat. On the third issue, Madam Co-Chair, we have a few issues that we wish they could be highlighted, or that we want to highlight or react to. Once again, we stress the critical importance of facilitating participation by delegates at the meetings that would be hosted in the where the Secretariat will be hosted. This includes issues of visa waivers, simplified entry, and funding for least developed states. Our concern is the linkage of this to the decision-making legitimacy. For an example, without effective participation, the low thresholds in the rules of procedure of the COP could allow decisions excluding large groups of states. This is extremely important for our group, and we would like to see reflection of that. Once again, we underscore the need for explicit wording on ensuring that the headquarters agreement includes obligations on the host state to guarantee access and not impede participation. Also, we consider proposing a reference to regional balance and equity in participation as a cross-cutting principle. Madam Chair, these are our preliminary points on the report that has been tabled. We reserve our right to come back on the issue, including on the question that you posed earlier on. We will prepare ourselves, coordinate further, and we may come back on a more detailed input. Thank you so much.
I thank South Africa, speaking on behalf of the African group, and appreciate the group's identification of elements of high priority. We would certainly welcome you coming back at some point in time on some of the next steps. We now have 3 different ideas on the table, one from AOSIS with two potential documents for PERCOM 3, and then the recently suggested proposal from the European Union regarding a letter and a potential draft decision to be prepared for PERCOM 3. So yes, we would very much appreciate if you can come back after having had an opportunity to reflect on that. I now recognize Mexico, who will be speaking on behalf of CLAM, I presume? Yes, Mexico.
Muchas gracias, Presidenta.
Thank you very much, Madam Co-Chair. First of all, CLAM reiterates that our central goal is to ensure the establishment of a fully functional secretariat tailored to the needs, objectives, and challenges of the agreement. To achieve this, CLAM believes that it would be beneficial to move towards an ad hoc institutional model that would be guided by the principles of efficiency, efficacy, transparency, inclusion, accountability, and adaptability. On the question asked by the co-chairs, CLAM considers that the co-chairmanship could prepare a draft model an ad hoc one for the BBNJ Secretariat that would include the elements that we mentioned previously and that are reflected in the note prepared by the co-chairs. We underscore the following elements in this first intervention. The Secretariat should benefit from be an international legal entity and have the necessary capacities in the host city according to Article 50, paragraph 3 of the agreement. CLAM believes that an evolving approach would be beneficial that enables a progressive growth of the Secretariat as the functions and needs of the mechanism increase, always with criteria of flexibility and cost effectiveness. When it comes to the appointment of the person in charge of the Secretariat, CLAM proposes a regional rotation mechanism through which each group would appoint or nominate a person with the qualifications required for their subsequent election by the Conference of States Parties to the agreement. The mandate could be for a term of 4 years with the possibility of re-election for an additional term. Finally, CLAM suggests that the Office of Legal Affairs, the OLA of the UN, could provide guidance on the type of specific instrument to sign up to achieve this proposal. Thank you very much, Madam Co-Chair.
I wish to thank Mexico, speaking on behalf of CLAM, and for making this suggestion. And I think I've missed one of the points that was raised even in AOSIS, and now that you're also raising it here. There's an interest, at least in respect of having some type of clarification on the level of autonomy versus a desired relationship with the UN. And I guess it goes back to the question I had to the EU on it would be helpful to understand what's the timing that delegations might have in respect of receiving that type of clarification in light of the dates that we already have for PrepCom 3. So if you guys would, sorry, that's too informal. If delegations would like to come back in to clarify, that would be good. I would like to give the floor now to Norway.
Thank you, Madam Co-Chair, and thank you for the paper, which we think is a good summary of our discussions and also a good starting point for us to put these elements down on paper. We agree that the paper outlines the main elements for the arrangements of the Secretariat and appreciate that it is not intended to be an exhaustive list. As I touched upon in our intervention earlier this week, in addition to the key principles of effectiveness, efficiency, transparency, inclusivity, accountability, adaptability, and international visibility, which are already reflected, Norway places particular importance on the principles of impartiality, competence, and professionalism. We believe that these are essential, both in terms of the overarching principles that guide us in this process, but also more specifically in relation to the appointment process for the head of the Secretariat and staff selection more broadly. In our view, it is key to ensure that the relevant candidates have the appropriate qualifications and expertise, in addition to ensuring an effective and transparent process and taking equitable geographical representation and gender balance into account. In terms of concrete outputs in the form of documents, we are open to hearing other delegations' views on this, and we are still considering, obviously, the ideas made on the floor today and more broadly. I would like to say, though, that the question posed by Palau on behalf of AOSIS regarding the options for selecting the head of the Secretariat and the potential legal implications of this choice was a good one, is a good one, And we agree that this is important information for the PrepCom to have when we get into the more granular discussions on that topic. Thank you for it.
Thank you very much, Norway. Iran, you have the floor.
Thank you so much, Madam Co-Chair, and thank you for providing us with the proposed elements. And our comments are very preliminary because we did not receive that document, and I will reach out to our distinguished colleague in the Secretariat to make sure that all delegations, including my delegations, are duly receiving these documents. But as we are looking into this document, which I informally received from one of my colleagues, we do not want to repeat our statements under this cluster, but just preliminary remark. As I mentioned, we believe that it's of practical utility to also establish a committee on relations with the host country, which is usually the practice also within the United Nations systems. It would help ensure that appropriate collaboration and cooperation is being done throughout this framework to ensure the independent exercise of functions of representatives. And maybe just mostly as a legal consideration, we believe that legally speaking, there is no need to distinguish as between the privileges and immunities of representatives of state parties and those of observers. And I don't believe that has been the practice within the international legal frameworks. The mere fact that those delegations are representing a state, a sovereign state, confers upon them the privileges and immunities, just for legal clarity on this. And we're pleased to see that there is a reference to the broad scope of privileges and immunities for representatives. And I'm sure that when we enter into very detailed discussions, we could speak about what elements it could take into account. But as we mentioned before, unimpeded transit and sojourn to and from the host country, and no requirements for visa. But if in any case, if there is a requirement for visa, that should be promptly issued. And these are topics that I'm sure that we will have time later to touch upon. On the heads of the Secretariat, I believe, if I'm not mistaken, the distinguished representative of CLAM mentioned that there should be a kind of geographical rotation. We also concur with this. It is good to ensure inclusivity through geographical rotation of the heads of the Secretariat. That is what we could support. And related to the question of qualification, of course, the staff of the Secretariat should possess qualifications and expertise. This is quite clear. But as we mentioned, this should not undermine the very fact that developing countries need to be well represented within the staff composition. And I believe there was some suggestions by the group of 77 and China on some possible options that could just help ensure that there is no underrepresentation or unrepresentation of developing countries. On the host country agreement, I believe at some point in future, it would be good that the PrepCom be duly seized of possible elements that the future host country and the Secretariat would conclude as headquarters agreement, because we know that it's usually a document that is concluded between the host country and the Secretariat. But I believe all member states are duly entitled to also be informed of those elements. And these are the general remarks that I wanted to mention here on the topic of the Secretariat. We will reflect a more detailed position on this, and I believe that we need to be more time efficient, and I'll try my best. Thank you.
Thank you very much, Iran. I now give the floor to the United Kingdom.
Thank you, Co-Chair, and good morning, colleagues. First of all, thank you to the Co-Chairs and the Secretariat again for producing another document at very short timing, and we very much appreciate all the work that's been put into this. From the United Kingdom's perspective, we are broadly content with the direction of that document. We think it captures the elements that were discussed. We, of course, heard some very interesting interventions this morning with proposals for other documents, which we would like to consider. We hope colleagues will share those interventions to the website, because it can be difficult to capture everything as they're being presented. We think there were some good ideas. We would very much agree with Norway and the points they made about impartiality, competence and professionalism as key principles for the Secretariat. We also agree that the question posed by AOSIS on the options for appointing the head of the Secretariat is a good one. It probably does make sense that we ask that question before we head down a route that we then find out is not possible. We did have a specific question for CLAM, if we may, on their proposal. We had understood that they are proposing a fixed geographical rotation for the head of the Secretariat, and we were just wondering how that would work in practice. We understand the principle of equitable geographical representation and endeavouring for that. But if it was some form of fixed rotation, would that mean you could only accept candidates from one of the UN regional groups? We would assume it wouldn't put us in a place where effectively one regional group was selecting the sole candidate. Thank you.
I thank the United Kingdom, and I take note of the question to Mexico, and I will offer the floor to Mexico when they press their button. In the meantime, I will give the floor to Micronesia, speaking on behalf of PCIDS.
Thank you very much. And first of all, AOSIS has already expressed, of course, the various points. So I just wanted to reflect on a few things that came up in the morning session. I guess one of the questions that we're looking at is, so who will decide the head of the Secretariat? Is it going to be the states through the COP? Is it going to be the Secretary General? So I was thinking a little bit along the lines of what does that mean for the argument of it should be a transparent process. Normally, if someone like the head of UNDP or UNEP is chosen, which is under the purview of the Secretary General, if I'm not mistaken, he would normally only really show one candidate and then basically ask around, make sure that there are no bigger political issues buried. I don't seem to recall that there was ever a process where he was like, oh, there is a couple of them. Now, if I contrast that with, let's say, the election of the Secretary General of the UN, where you could have several candidates, the practice nowadays is that there are public hearings. It was not always the case, but it has become a practice where each candidate would get an opportunity both to sketch out their vision as well as then to answer questions that are coming forward. Now, in regards to the question that the UK just asked about, how does that work in terms of rotational? Well, I would put it like that. In some cases, it does work, and in others, not so much. In terms of the Secretary General of the UN, it's only an understanding, and that has been broken a couple of times. But for example, the main committees of the General Assembly, there is a schedule of like, okay, this year this group is chairing, and this group is chairing the next one and this one, and then the next year it's a different way. And what you would have is only the group that's named you would only find a candidate from within the group that is named for that year. So if it is, let's say, the term of the Latin American and Caribbean countries, then only those would nominate someone. The others would not. Whether we can just transplant that, maybe, maybe not. In terms of one point that EOS has rightly made was, so does that mean the Secretary General is then the UN Secretary General is then responsible under certain circumstances? And I certainly don't have an answer on that, but perhaps it might be helpful to look at the specialized agencies, because they do carry the laissez-passer from the UN. And I don't know how that is exactly, whether it's the same or whether it says which organization, but that might be worth just having a quick look on how that works in practice. And the final point also on the laissez-passer is the reality is it's only as good as the host country makes it. There are very few privileges with the laissez-passer these days. Most countries, including various countries hosting UN entities, still go by nationality. So it's not enough to just show up with the UN passport. You still have to have the required visa showing that you're posted there or that you're attending a meeting, etc. So that could be also something for the two prospective candidates to think about, how far they would want to go in their offer. There are other countries in the world where you basically show up with the UN passport and it's as good as a diplomatic passport and you get to join the short line. But the point that I'm making is the utility of that passport is not going to be so much for the secretariat staff to travel somewhere else, but for them to come back to their post. And those are just reflections. Thank you very much.
Thank you very much, Micronesia, for sharing those observations on behalf of the PCIDs. I now give the floor to Canada.
Thank you, Co-Chair. Thank you, Co-Chair. Apologies for the technical issues. We don't want to take more time and repeat what everyone else said. We largely would like to echo some of the considerations that were expressed by Norway. We're also interested in the same considerations that were expressed by United Kingdom. And we would like to particularly highlight the importance of qualifications, meaning that the head of the secretariat and the staff do need to be highly qualified. So we will be paying close attention to these aspects. Thank you, Co-Chair.
Thank you very much, Canada. China, you have the floor.
Thank you, Co-Chair. We thank the Co-Chair for circulating working paper elements regarding the Secretariat's arrangement. China believes that this document incorporates the views expressed by parties at previous meetings. We're willing to conduct discussion based on the text. At this stage, we wish to offer the following preliminary comments on its content. First, regarding missing elements in the document, China knows that during previous discussions, many delegations from various angles brought up the conditions that host countries should provide for the functioning of the Secretariat, including but not limited to appropriate safety and security for Secretariat staff and participating representatives, infrastructure for the Secretariat's offices and hosting of large meetings, and technical and possible financial support for the Secretariat's operations. The Secretariat is also responsible for managing the CHM. CHM should facilitate parties' access to and sharing of information. Therefore, the host country should provide appropriate conditions for the storage and access of relevant data. China proposed that those elements of the conditions be included in the current text and is open to comments and suggestions from other delegations. Second, regarding improving the existing elements in the current document, China would like to share 3 suggestions. First, regarding the guiding principles of the Secretariat's arrangement. In its previous statement, China pointed out that the Secretariat, as the administrative hub of the agreement, should play its role in balancing the due objectives of conservation and sustainable use of BBNJ. It should also maintain operational neutrality, adhere faithfully to the provisions of the agreement and the mandate of the COP, provide services to all parties impartially, and cooperate with other IFBs without undermining their mandates. Therefore, China proposes adding 4 elements to the first sentence of the arrangement, which I will read in English.
A, attainment of conservation and sustainable use of BBNJ. B, impartiality. C, guided and supervised by the COP. And D, cooperate and coordinate with while not undermine other IFBs.
At the same time, we have some doubts about the meeting of international visibility. For a treaty as important and influential as the agreement in global ocean governance, its secretariat naturally attracts close international attention. This goes without saying, and seems unnecessary to make international visibility a guiding principle for the secretariat's functioning. In fact, what we should really guard against is that if international visibility is to be a guiding principle, it may create the risk of Secretariat expanding or exceeding its authority, thus exacerbating its self-legitimization. This will be detrimental to the full and effective operation of the agreement. Therefore, China holds a prudent attitude towards this reference. Second, on privileges and immunities. China believes that privileges and immunities for Secretary staff and participating representatives should be granted to safeguard the performance of their functions. Therefore, China proposes adding the phrase "for the execution of their functions" to the end of the second point of the PIA. I'll read in English.
Privileges and immunities to be granted to the Secretariat and its staff and dependents, as well as representatives of state parties and experts participating in the meetings of the bodies established under the agreement for the execution of their functions.
In addition, in the first point under the facilitative elements, namely safeguards, China proposes adding before the comma of the sentence
and regulation of the host state.
To demonstrate the respect for the domestic laws and regulations of host country and avoid potential dispute arising from the Secretariat's operation in the future. This is also consistent with Article 26 of the Vienna Convention on Diplomatic Relations. Third, regarding the selection and the appointment of the head of the Secretariat and the selection of the staff, China emphasizes that developing countries should not only enjoy equitable representation in the Secretariat, but also receive priority under equal conditions. Therefore, China proposes changing the phrase
states, 改为 preferable representation of developing states.
In conclusion, China wishes to reiterate that the PrepCom should focus on discussing the Secretariat's functioning model. China supports adopting an independent Secretariat model similar to that of the International Seabed Authority. In the meantime, the PrepCom can also discuss the criteria and procedure for selecting the Secretariat's seat. The decision on the seat can only be made by COP1. Thank you.
I thank China for highlighting some of the elements in the document and also clarifying issues around the reflections on principles. We will take up the issue of the seat this afternoon. So we will look forward to comments then in terms of modalities and processes. I wish to give the floor to Malaysia, followed then by Japan, Australia, and then Russian Federation.
Thank you, distinguished co-chairs, for giving Malaysia the floor. As Malaysia is taking the floor for the very first time this session, we would like to extend our appreciation to the co-chairs for providing the revised aid of discussion on the topics for the session, and also the document on the overview proposed elements for arrangements for the functioning of the Secretariat. Malaysia notes that the proposed elements are non-exhaustive in nature. As a preliminary observation, Malaysia supports the inclusion of the element of equitable representation of developing states in the appointment process of the head of the Secretariat and staff selection. On that note, Malaysia wishes to highlight that this element should be further considered, that developing countries have unique interests, needs, and priorities. Therefore, it's essential for the Commission to explore tailored approaches that ensure these developing countries are well represented in the respective appointment and selection processes. I thank you.
I thank the representative of Malaysia. I now give the floor to Japan.
Thank you, Madam Chair, for giving me the floor. And firstly, I'd like to thank you for the swift production of the document, which does facilitate the consideration in the Commission. I just have a few provisional reflections to share. Firstly, and it also overlaps with many points already raised, so I'm not taking much time. Firstly, in terms of the size of the Secretariat, we share the point made by African Group on that it should start lean in the beginning. I took a look again at the matrix and then noted that both ISA and CBD Secretariat started at a number around 20 to 30, and then over time it grew. It's important to keep the scale at the manageable size for both the cost efficiency and swift startup after the entry into force, which is seen to come soon. We also share the view by Norway and also UK on the importance of impartiality, competence, and professionalism in the appointment of the head and staff recruitment. Also, we have a similar view and question on how to take into consideration the regional rotation aspect. And it is normally something which is taken into consideration in the actual selection process, but we'd like to take a prudent approach in institutionalizing it. And lastly, in terms of the international legal capacity, we note that Article 50, paragraph 3 refers to the legal capacity, but it's in the host nation. And our understanding is this is something at the national level to allow the Secretariat to be able to enter into various legal contracts and so on. But when it comes to the international legal capacity, I'm not sure what exactly we're envisaging. Whether it's something going beyond to let the Secretariat to enter into some international agreement and become an entity to such such arrangement. So we'd like to take a careful view on what it enables and what's the implication is. Lastly, we'd like to take note of the points made by China on visibility and keep it in mind. Thank you. This is all from now.
Thank you very much, Japan. Australia, you have the floor.
Thank you, Chair. Thank you for the overview, or yourselves and the Secretariat, of the proposed elements for the functioning of the Secretariat. Like the United Kingdom, the EU, Norway and others, we are broadly content with the document. Like Norway, the United Kingdom, Canada and Japan, Australia supports the key principles of impartiality, competence and professionalism, which are particularly important for both the selection of the head of the Secretariat and the staff of the Secretariat. We thought the list of matters the EU proposed for raising with the United Nations a good one. Whether this should be done by a letter to the Secretary-General, as we also initially proposed, or some other process, it might be useful to get some guidance from the UN on the best way to approach this. The process for the UNFCCC's institutional linkages with the United Nations involved a letter to the UN Secretary-General, but we appreciate that exchange occurred 30 years ago. We think an approach should be made as soon as possible, vis-a-vis your question on timeframes, so we could be assured of any response prior to PrepCom 3. Like Norway, we also think the question raised by Palau on behalf of AOSIS about what legal effect, if any, would be the appointment of the head of the Secretariat on the institutional linkages with the United Nations is a good one. An answer to this question could form part of any guidance we might receive from the United Nations. Thank you, Chair.
Thank you very much, Australia. I wish to give the floor to Russian Federation.
Thank you, Madam Chair. And I thank you for sending the basic elements that we're discussing and which build on the other discussion. And so I thank you for that in particular, because I wasn't around for some of those discussions. We weren't able to track it. At the last section, we voiced in detail our position on the Secretariat and the main, but in practice, of course, in international practice, if you take the Antarctic Treaty, for example, then the Secretariat established a Secretariat later on. It wasn't there initially, and then it was created. And then it was stipulated that for the Secretariat to work as a subject of law, that is not as a fully international subject of law, but just a subject of law, it had the right to establish a headquarters in the state, the relevant state where it was, in order to have the relevant privileges and immunities. But in other contexts, it was the case that the Secretariat was not created because a separate Secretariat wasn't established, because no agreement was reached to that effect. And in this case, I think, of course, considering the importance of the Convention on the Law of the Sea, and naturally of all of the other international agreements reached under the UN in terms of the law of the sea, the Secretariat of the Doualos is perfectly fine for us. That is, I would like to point out the agreement in Article 50 that the Secretariat of the Conference, well, it's important to understand that the Secretariat of the Conference is accountable to the Conference. The Conference is a political body, and it can't confer more powers than it has, because it doesn't have the powers as a subject of itself. So that is provided that the Secretariat isn't, the role of the Secretariat isn't taken on by the UN. So in that case, the functions stipulated in 4D, that's needed simply so that as a subject under law, it is able to shoulder the necessary functions that have to do with the legal relationships among states so that it can be a legal entity. Thank you.
Thank you very much, Russian Federation, for those reflections. Colleagues, the Russian Federation was the last state to request the floor, and I have no other speaker. Oh, Palau. Palau, you have the floor on behalf of the Alliance of Small Island States.
Thank you, Madam Co-Chair. Just trying to respond to the questions you posed earlier. We do see the benefit of having this advice, and this to your question about timing. We do see the benefit of having this advice by PrepCom 3. So our recommendations can be informed by this advice. We note that there are different advice being requested, and we are flexible to ensure all delegations get the advice that they require to move forward so that we can finalize, so we can have useful advice ahead of finalizing our recommendations for the consideration of the COP. Madam Co-Chair, we do want to say that the request for advice does not prejudge the decision of the COP that they will ultimately take on the model. I think we shouldn't, if you like, lead the UN on until we've taken a decision on the model. So this is really to inform our recommendations that we will subsequently take and finalize at PrepCom 3. Just on the point Japan raised, and this is just a reiteration of AOSIS's position, we do see having international legal personality and legal capacity in the host state as two different things. Thank you.
Thank you very much, Palau, speaking on behalf of AOSIS. I give the floor to Mexico, speaking on behalf of CLAM.
Gracias, Co-Chair.
Thank you, Co-Chair. Just in response to your question on the timing, we agree with the relevance of having information prior to the third PrepCom so that we can have time to think further, to reflect further and make a decision. Thank you.
Mexico, European Union.
Thank you very much, Madam Co-Chair, for giving us the floor again. I will deliver some points of reply on behalf of the EU and its 27 member states. First of all, thank you for asking for a clarification on the timeline, and apologies for not mentioning it earlier. I agree with my distinguished colleague from Mexico that we need to have documents in a timely manner. So in this respect, the EU and its 27 member states would prefer for the letter in which a PrepCom would request the UN Secretary General advises the PrepCom on institutional arrangements to be sent by the end of the year. This would ensure, in our view, that the reply will be sent back in advance of the time scheduled for the commencement of the PrepCom 3, which will commence on the 27th of March 2026. Seems quite far away, but I think we all know that time flies. In relation to the question of how we would give effect to international legal personality for the Secretariat, in our view, this could be achieved through complementary resolutions being adopted by the BBNJ COP and by the UN General Assembly. These resolutions would grant juridical personality as is necessary for the effective discharge of the Secretariat's functions. And this would give effect to Article 50, Paragraph 4 under D of the agreement. And we would welcome a draft decision from the co-chairs to give effect to this. In addition to CLAM's proposal requesting Dualis to prepare a draft ad hoc Secretariat model for the BBNJ Secretariat, which we believe would most certainly help in advancing the discussions on this matter, it would be very useful for Dualis to prepare an indicative budget for such a model, as was also suggested by the African group and by Japan. Regarding the accountability of the head of the Secretariat, we are still considering how it would operate. One function could, for example, be for the head of the Secretariat to have 2 lines of accountability, namely on policy matters arising from the terms of the agreement to the COP, but also on staffing and the administrative matters to the UN Secretary General. However, we would also welcome hearing the views of other delegations on how they would see such arrangements functioning in practice. Finally, we full-heartedly agree with our colleague from the UK that it would be very helpful and thus very much appreciated for the written statements to be submitted and circulated, as indeed it can be quite difficult to capture all of the elements expressed by other delegations. Thank you very much, Madam Co-Chair.
Thank you, European Union. Thanks for the clarifications that you've made and reactions to the proposals that have been made on the floor. I wish to give the floor to Iceland.
Thank you very much, Madam Co-Chair. We would just like to take the floor briefly. At the outset, we thank you and Dwalas for the overview of the proposed elements for arrangements for the functioning of the Secretariat, which was submitted to us. And like many other delegations, we are broadly comfortable with this document as a useful basis for our discussions and the direction that the discussions have been going in this morning. And we just want to limit our intervention to registering Iceland's support for impartiality, competence, and professionalism as the key principles applicable to the appointment of the head of Secretariat and the staffing of the Secretariat, as was mentioned by Norway, the United Kingdom, Canada, Japan, and Australia. Finally, we also just register our interest in receiving guidance on the consequence of the appointment process for the head of the Secretariat, which may what consequences it has for the potential interlinkages with the United Nations. Thank you.
Thank you very much. Iceland. Oman, you have the floor.
Thank you, Madam Co-Chair. My delegation thinks that it is important to clarify a number of ideas that would be useful. First, the document does not clarify the organizational structure of the Secretariat and the staff. Second, the mechanism for the selection of experts and the Secretary General. We don't understand what are the qualifications and the controls for the selection. Third, this Secretariat would be affiliated under who and who would review its budget under the agreement, of course. Four, is there a committee that will be elected to review the work of this agreement, as is the case for other agreements?
I thank Oman, and yes, thanks. Oman was the last state to request the floor, so I will now give the floor to our observers. And the High Seas Alliance NGO 24 has requested the floor. You have the floor.
Thank you, Co-Chair. We thank the Co-Chairs for the Secretariat overview paper. With respect to the last item, establishment of cooperation arrangements with regular IFBs, we would make two suggestions. Firstly, Article 50, Paragraph 5, Subparagraph D, empowers the Secretariat to facilitate cooperation with IFB secretariats. This will be an important function to pave the way to efficient cooperation mechanisms. Similarly, the convention or the agreement empowers the Secretariat to enter into administrative arrangements with COP approval. For example, this would ensure that IFBs are notified of consultation opportunities and deadlines. So we suggest this could be stated in the overview paper. And secondly, the Secretariat will work together with the clearinghouse mechanism to disseminate timelines, documents requiring IFB input and consultations. And the clearinghouse mechanism will also serve as a portal for information sharing with IFBs. We think that the paper could also state that the mechanism will coordinate with the IFBs consistent with Article 51, Paragraph 4, as well as other IFBs as determined by the COP. Thank you, Co-Chair.
I thank the High Seas Alliance. I wish to give the floor to Russian Federation.
Thank you, Madam Chair. Pardon me, I didn't want to speak under this item at all, but having mentioned paragraph 4D, which says that the Secretariat has administrative and contractual arrangements under its control and carries out cooperation and coordination. Given all that, of course, it can't enter into international agreements if it doesn't have legal personality itself. and legal ability to conclude such international agreements. In that case, it would only be the UN. The secretariats of other bodies don't always have legal personality and aren't always able to legally enter into agreements. I just wanted to clarify that point. Thank you.
Thank you very much, Russian Federation. The Russian Federation was the last speaker on the list, and I will attempt to quickly indicate where we stand. First of all, thank you to all delegations for engaging with the text and for indicating generally that the elements that were discussed have been captured, but noting that there are some additional elements that would need some reflection, were these to be then generated into a text that the co-chairs would provide for PREPCOM 3. In terms of some of the suggestions, and we take the point that has been made from several delegations requesting the written statements to be forwarded to Wallace@un.org. But from my reading of what has been proposed, there is an interest in having some further clarifications without prejudging what model of arrangement would occur, but that clarification would be in relation to certain issues regarding the relationship with the UN, including in regards to the questions of appointment of head of secretariat. And that seems to be a suggestion that has gained some interest across the room. There is obviously the ultimate endpoint for PREPCOM 3 would be to have a draft decision that sets out the issues regarding arrangements. There's been a proposal that a potential document could set out the different models. And I would recommend or encourage you to discuss that proposal amongst yourselves. We do not come back to this item until Thursday next week. In the meantime, my co-chair and I will be holding consultations, including with the Bureau, on those next outputs for PREPCOM 3, so that when we come back together on Thursday next week, we can have clearer guidance on how we proceed. Thank you very much for your engagement on that issue. And now, since we do have a little bit over an hour, I'm supposed to either close or adjourn? No, not close. We will now adjourn informal working group 1 and reconvene in plenary to open item 7 of the agenda, other matters, for an exchange of views on the process for the 9th replenishment of the Global Environment Facility Trust Fund. So we're adjourning the 1 and then resuming our plenary to open agenda item 7 of the agenda. Okay, I don't think I need to use the gavel. Distinguished delegates, we shall start our consideration of item 7 of the agenda, other matters. Do you want to do that? Oh, so let me give you a 5-minute break then. Thank you, sorry, I'm a taskmaster.
Thank you, delegations. We shall start our consideration of item 7 of the agenda, other matters. We wish to recall that the process for the 9th replenishment of the GEF Trust Fund, to cover the period from 1 July 2026 to 30 June 2030 is ongoing, with the 4th replenishment meeting, which will finalise donor replenishment pledges, scheduled to take place from 16 to 18 March 2026. Therefore, it has been suggested that the timeline for the PrepCom to propose provisional guidance for GEF 9 replenishment meetings to consider should happen in time for the 3rd GEF 9 replenishment meeting to be held in January 2026. At PrepCom 1, we held a preliminary exchange of views on this issue. During that discussion, there was general support expressed for ensuring adequate resources were allocated during the GEF 9 cycle for the implementation of the agreement. However, it was agreed that further consideration was needed regarding the possible role of the Commission in providing such guidance. I think, to put it simply, as there is recognition everywhere, the reality is, at the moment, this Commission is, if you like, the institutional framework that the BBNJ has. So in terms of any BBNJ input or any input on behalf of the BBNJ regime into the 9th replenishment cycle, it must come from this preparatory commission. We are institutionally the BBNJ such as it exists at this point in time. With that, the floor is now open for comments. After we've exhausted the list of speakers, we will then invite delegations to react to the comments received. I see that Palau has asked to take the floor, speaking, I presume, on behalf of AOSIS. Palau, you have the floor.
Thank you, Mr. Co-Chair. I have the honor of delivering this intervention on behalf of the 39 Small Island Developing States, members of the Alliance of Small Island States. In response to both the draft GEF 9 Strategic Positioning and Programming Directions and the GEF Secretariat Information Note dated 18th August 2025, our group would like to make the initial observations. So first, BBNJ and other international water matters deserves their own focal area separate to the transboundary water matters. The legal frameworks and approaches to solve these global environmental issues are different. Next, we would like to have a focus on needs that are placed on the following areas for the support of developing countries, especially small island developing states and indigenous peoples, as well as local communities under the GEF 9 replenishment. So first, we'd like to see continued support for ratification of the agreement. Then we'd also like to see support for enabling activities, especially for the preparation of needs assessments and reporting. And then lastly, support for capacity building. As it relates to the GEF 9 policy directions, AOSIS is of the view that the GEF system for transparent allocation of resources must finally address its bias towards terrestrial global environmental challenges. As one of the operating entities of the multilateral regime seeking to govern the conservation and sustainable use of biodiversity in 65% of the ocean, the GEF must stand up not only in its words, but also as it relates to its actions. So the policies of the GEF must adapt. Lastly, our group also wants to reiterate key initial positions we mentioned earlier on the matter of initial guidance of the operating entities of the financial mechanism that must also be addressed in the GEF 9 discussion. For eligibility, the GEF must ensure that all developing country or all developing state parties, especially all UN recognized SIDS, are eligible for finance under its programming. Then next, for overall strategies and policies, the GEF needs to fully operationalize the principle of the special circumstances of SIDS and LDCs, which must be dealt with in all aspects of the GEF, especially its access, allocation, and resource distribution. Also, quite frankly, the GEF is being left behind. It's being left behind with regards to the empowerment of developing countries through the use of a simplified direct access modality. True direct access at scale, and at scale is underscored, to GEF resources must be done through subnational, national, and regional entities and indigenous peoples, as well as local community entities. This is the only path to ensuring sustained capacities within developing countries. We must transition away from the model that relies solely on international and regional intermediaries who are expensive and generally removed from the context in which they're working. Next, for programming priorities, the GEF shares a mandate with the Special Fund based on Article 52.6. As noted, the agreement also requires complementarity and coherence. On that, AOSIS would like to remind the GEF9 replenishment process that the sole prerogative lies with the BBNJ COP, as stated in the BBNJ agreement, and reaffirms and as reaffirmed by the GEF Secretariat in its information note. Our group are, however, we want to reiterate the initial priorities that we highlighted above. Taking a step back to focus on the BBNJ financial architecture, AOSIS reiterates its resolve that the Special Fund will be the central and prominent entity, both within the BBNJ financial mechanism and the broader financial architecture. The BBNJ regime needs a dedicated, fit-for-purpose fund like the Special Fund to program finance at scale, while being supported by a cross-cutting enabling fund like the GEF, which supports at least 6 multilateral environmental agreements. Co-chairs, in closing, AOSIS continues to look forward to constructively engaging with colleagues on this matter, and we thank you.
Thank you very much, Palau, speaking on behalf of AOSIS. And I now give the floor to Papua New Guinea, speaking on behalf of PSIDS.
Thank you, Co-Chair. Co-Chair, I have the honor of speaking on behalf of the Pacific SIDS and align our remarks with those made on behalf of AOSIS. The PSIDS support the Preparatory Commission, providing timely provisional guidance to the GEF9 replenishment process. The provisional guidance must reflect and operationalize the principle of the special circumstances of small island developing states. The provisional guidance should include references to, among others, needs assessment, capacity building, and indigenous peoples, as well as local communities, including women and youth within those communities. We are open to considering other important funding needs to be included in the provisional guidance. Thank you, Chair.
I thank the distinguished representative of Papua New Guinea, speaking on behalf of PSIDS, and I give the floor to Brazil, speaking on behalf of CLAM.
Thank you very much, Co-Chair. I'll have the honor to speak on behalf of CLAM. CLAM recognizes the relevant support the Global Environment Facility has provided during this initial phase of preparations for the entry into force of the agreement. And at the same time, we believe further clarity is needed on what the Preparatory Commission can and cannot do in relation to providing guidance to the GEF. As there's no memorandum of understanding in place between the agreement and the GEF, let alone between this PrepCom and the Environment Facility, We would welcome clarification from the co-chairs on the possible format of any message to the GEF Council and on who would be responsible for transmitting this message on behalf of the Commission. Should the membership decide to move forward with such a message, CLAM considers that it should be subject to important safeguards. Firstly, the GEF must be seen as one of the operating entities of the financial mechanism, working in close coordination with the new special fund to be established. Second, any interim substantive funding should only take place once the agreement enters into force, an MOU with the GEF is signed, and programming priorities are formally adopted by the Conference of the Parties. Thirdly, in the meantime, the GEF should continue supporting developing countries in their efforts to sign, ratify, and implement the agreement. Additionally, CLAM sees value in exploring how the GEF can support the initial identification of needs and costs associated with the implementation of the agreement by developing countries. This would build on the GEF's comparative advantage in enabling activities and institutional strengthening, as well as support the process of defining the initial resource mobilization as per Article 52, paragraph 11 of the agreement. Finally, as colleagues from AOSIS always alluded to, we believe the PrepCom should seek clarity on the possibility of the BBNJ agreement becoming a dedicated focal area under the future GEF allocation system. Such an arrangement would be helpful to prevent competition for already scarce international waters focal area resources, which is currently the least funded under the GEF aid process. Thank you very much.
I thank the distinguished representative of Brazil speaking on behalf of CLAM, and I give the floor to the distinguished representative of the European Union. You have the floor.
Thank you, Mr. Co-Chair. I have the honor to deliver the statement on behalf of the EU and its 27 member states. On possible orientations for the GEF replenishment, of course, it will be up to the BBNJ COP to give guidance to the GEF for the spending under the GEF Trust Fund. The COP is not in place yet, but we will look forward to have the COP soon in place and to be quickly able to provide the guidance the GEF needs so that the most pressing needs of BBNJ developing parties can be met swiftly after the entry into force of the agreement and in the programming of the 9th GEF. In that perspective, and as far as the EU and its member states are concerned, we see positively early interactions with the GEF to support timely implementation of the agreement, considering also our objective to have SDG 14 achieved by 2030. Therefore, we see added value in the Preparatory Commission to provide guidance for the GEF 9 strategic positioning and programming directions, and in having the co-chairs relaying to the GEF a limited number of broad consensual orientations by the PrepCom that could help GEF in the preparation of its discussions on the 9th replenishment. Among these orientations, we would see, firstly, the continuation of the support activities to developing countries for the ratification and preparation of the implementation of the agreement. A lot remains to be done in this respect, and it has never been the intention to stop the support once the 60 ratifications would be reached. Our common goal is to make this agreement universal and to create the best conditions for its implementation by all. Secondly, the GEF could provide support for enabling activities, so for example, studies, meetings, and pilots, that the COP could find useful for strengthening the foundations of the agreement and the development of the activities under the COP and its bodies. Thirdly, and considering that the effective implementation of the agreement will rest on the assessment of the needs by the parties, particularly in matters of capacity building and technology transfer under the guidance of the COP, The GEF could help in supporting developing countries in their state-led process for needs assessment. It would also help in their participation and contribution to the elaboration by the COP of a strategy for the effective implementation of the agreement based on those identified needs. The strategy would define priorities for guiding the coordinated and consistent intervention of the different elements of the financial mechanism, and to monitor this intervention involving the relevant agreements committees as necessary. Fourthly, the GEF could be suggested to envisage the mobilization of funding for some pilot or flagship initiatives for the conservation and sustainable use of biodiversity in areas beyond national jurisdiction, to be defined by the COP at a later stage, which would also aim to test and further improve the cooperation mechanisms in place. The EU and its member states are ready to further elaborate on those orientations at this PrepCom in cooperation with the other delegations, following the format that the co-chairs would deem the most appropriate. Thank you very much.
I thank the European Union very much for your intervention. Delegates, a quick snapshot of the state of play. I have one further speaker inscribed, that is Guyana, on behalf of CARICOM. We would then propose to try and exhaust the remainder of yesterday's speaking list on rules of procedure. It would be very advantageous for our proceedings overall if we were able to complete the rules of procedure item under interpretation, and this morning, bearing in mind that we are tasked to produce a paper for the consideration of all delegations for next week's proceedings. With that, I will give the floor to Guyana, speaking on behalf of CARICOM.
Thank you, Mr. Co-Chair. I have the honor of delivering this intervention on behalf of the member states of the Caribbean community. CARICOM would like to align itself with the statement delivered by the Alliance of Small Island States. CARICOM notes that the GEF9 replenishment process is underway, setting the stage for the next cycle, which will be between the period July 2026 to June 2030, during which time we anticipate the entry into force of the treaty and the convening of the first COP. As this cycle is a critical opportunity to ensure that the GEF's resources are aligned with the goals of the BBNJ agreement, CARICOM proposes that the co-chairs formally communicate with the GEF Secretariat to highlight the emerging financial needs of the BBNJ agreement that need to be reflected in the GEF9 replenishment priorities. CARICOM also proposes that the co-chairs seek opportunities for the PrepCom to participate as observers in appropriate GEF replenishment meetings with a view to ensuring that the interests of developing states under the BBNJ agreement, and as outlined in Article 52(6), are brought to the attention of donor countries, and that the PrepCom is updated on the outcomes of GEF9 deliberations relevant to BBNJ. CARICOM wishes to underscore that engagement with the GEF should prioritize the urgent financial requirements of developing countries, particularly small island developing states, least developed countries, and landlocked developing countries to participate fully in the agreement's early implementation phase. I thank you.
I thank the distinguished representative of Guyana speaking on behalf of CARICOM, and I give the floor to Malaysia.
Thank you, distinguished co-chairs. Malaysia welcomes the detailed obligations placed on GEF to provide a comprehensive reports on its activities, including project approvals, the outcomes, and the resource mobilization. We encourage the reporting also include information on accessibility and equity of funding, particularly the extent to which developing countries are able to access resources without undue administrative burden. Regarding the periodic review and independent assessment, Malaysia strongly supports the provision for periodic review of the financial mechanism. We believe these reviews should be inclusive, transparent, and participatory, and that independent assessment should evaluate not only effectiveness, but also fairness and equity in resource allocation. Our resource mobilization, Malaysia appreciates the linkage between the COP Finance Committee's recommendations and the JEF replenishment process. We encourage the exploration of innovative financing approaches, including the blended finance and partnerships with regional and private sector initiatives to ensure sufficient and sustainable resources for implementation. Malaysia also supports the provisions on complementarity and coherence, stressing the needs for synergy between JEF funding and other international funding mechanisms, including the Green Climate Fund, the Adaptation Fund, and relevant regional initiatives in order to avoid duplication and maximize impact. Thank you.
Terima kasih, Malaysia, and I now give the floor to Australia.
Thank you. Australia is a long-standing partner of the JEF and highly supportive of its role as part of the BBNJ financial mechanism. And we acknowledge and welcome the contribution made by the JEF to date to provide states with BBNJ ratification support and implementation readiness. We welcome the information note from the JEF Secretariat to this PrepCom of 18 August, outlining the process and timing for the replenishment process and providing draft text for the programming directions. And we welcome that the draft text provides that support to the agreement will be one of the 3 standalone objectives of the international waters focal area, giving BBNJ appropriate prominence. We fully support the PrepCom taking up the opportunity now to provide suggestions and guidance on how the JEF should support BBNJ over its next replenishment cycle. And we support this guidance being provided as an outcome of this meeting. In terms of what the guidance includes, we offer our full support for the submission by PSIDS. In particular, Australia strongly supports JEF funding being directed to both needs assessments and capacity building. This will be important to ensure funding is appropriately targeted. We strongly support the guidance to the JEF highlighting the need to support programs by Indigenous peoples and local communities. And third, we consider the guidance should emphasise the importance of operationalising the principle of the special circumstances of SIDS. We also suggest that the JEF consider supporting developing states in pursuing all stages of the ratification process, including both building understanding of the agreement and legal drafting services as needed, supporting the BBNJ Secretariat and/or the COP in the staged development of the clearinghouse mechanism, supporting the scientific and technical body and other BBNJ subsidiary bodies as required to engage relevant experts in order to perform their functions, and finally, supporting parties in preparing ABMT proposals, including for the establishment of marine protected areas as an early priority for action under the agreement. Thank you, Chair.
I thank you, Australia, and I give the floor to Indonesia.
Thank you, co-chairs. Indonesia would like to first thank the co-chairs and the JEF Secretariat for preparing the document. And Indonesia would like to especially thank the support of the Global Environmental Facility for enabling and supporting the early ratification and the implementation of the BBNJ agreement within Indonesia itself. As an archipelagic state surrounded by areas beyond national jurisdiction, Indonesia underlines the important role of the JEF funding in supporting the implementation of the BBNJ agreement. With regard to the draft document prepared by the JEF Secretariat and the co-chairs, Indonesia fully supports that this is going to be the format of the document with additional elements that might be included. First, Indonesia highlights that once the COP has been established, the first COP should also address the question on GEF transition, especially on the programs that will continue being funded by the JEF. Second, following the operationalization of the subsidiary bodies of the BBNJ agreement, there should also be the role of Finance Committee in evaluating the disbursement and mobilization of the funds and ensuring that there will be no duplication on the utilization of both funds. Indonesia also agrees with the point that JEF should also take into account the guidance given by the COP. Third, Indonesia supports the possibility for a dedicated and inclusive funding stream within JEF 9 to support the implementation of the BBNJ agreement, as has been highlighted by a number of delegations, including CLAM. In this regard, Indonesia highlights the importance of the Coral Triangle region in the implementation of the BBNJ and propose further consideration of CTI region and other regional groups in the JEF replenishment meeting, as well as in possible allocation of the funding under JEF. Indonesia would like to echo the statement of the Malaysian delegation to ensure the transparency and accountability on the use of the JEF funding during the period prior to the entry into force of the BBNJ agreement as well, and supports dedicated provision on the reporting of the utilization of JEF funding in relevant financial rules or other rules that will be deliberated in the PrepCom, as well as within the draft MOU between JEF and the COP of BBNJ agreement. Thank you, co-chairs.
Terima kasih, Indonesia. I will now give the floor to the Seychelles to be followed by Vietnam, and that concludes our speaking list on this item. Seychelles, you have the floor.
Good morning, co-chairs. Thank you for giving me the floor to intervene on behalf of the African Group. As others have noted, the African Group would also like to respond to both the JEF Secretariat information note dated August 18, 2025, as well as the draft JEF 9 strategic positioning and programming directions. The African Group notes that under the JEF 9 replenishment cycle, there should be a focus for support to developing countries on these key areas: support for ratification and domestication of the agreement, support for implementation of the agreement through support for capacity building and enabling activities, especially for the preparation of needs assessments, reporting, and the enabling of filling the gaps identified from these needs assessments. The JEF Transboundary Waters thematic area is separate and apart from the BBNJ and the JEF Other International Waters thematic area. As such, the African Group notes that these should be dealt with separately. The African Group reiterates a few key points in regards to how some issues relating to the entities of the financial mechanism will be addressed in discussions of the JEF 9. In regards to eligibility, the JEF must ensure that all developing state parties are eligible for finance under all of these entities. As mentioned in our last intervention on the JEF must ensure alignment of its policies and architecture with modalities that ensure equitable access, allocation, and timely resource distribution. We reiterate the need for the JEF to adopt a simplified, direct access approach that is suitable for specific countries' needs. Based on Article 52.6, we note that the JEF shares a mandate with the Special Fund in regards to programming priorities, as other groups have noted. As noted by others, we also agree that the agreement also requires complementarity and coherence. The African Group notes that the JEF 9 replenishment process is directly related to the BBNJ COP, as is stated by the BBNJ agreement and reaffirmed by the JEF Secretariat and its information note. We also reiterate the African Group's priorities stated earlier in our last submission on the JEF. The African Group reaffirms that the Special Fund is central to the BBNJ agreement and is needed to program finance at scale, while being supported by the JEF as a complementary, cross-cutting, and enabling fund. Co-chairs, the African Group awaits your further guidance on how we may support further discussions on this issue, and we look forward to continuing to work with our colleagues in the room. Thank you.
Thank you, Seychelles, and my sincere apologies for failing to recognise that you were speaking on behalf of the Africa Group. So my apologies, and also my apologies to all members of the Africa Group. My mistake. And with that, our last speaker inscribed is Vietnam. Vietnam, you have the floor.
Thank you, co-chairs. Vietnam recognizes the important role of GEF for effective implementation of BBNJ agreement. In this regard, Vietnam proposed the procedure that parties to the BBNJ agreement can submit project proposal directly to the GEF Secretariat without the requirement of endorsement from the National Designated Authority, NDA, or a no objection letter. This simplified procedure would shorten administrative processing times and enable timely access to financial resources for BBNJ project. Thank you, co-chairs.
Thank you, Vietnam. And I now give the floor to the distinguished representative of China.
Thank you, Co-Chair. Regarding the replenishment of GEF, China believes that GEF Trust Fund is an important financial guarantee for the effective functioning of the agreement. Considering the 9th replenishment of GEF is coming soon, the PrepCom should provide guidance to the replenishment of GEF. It is appropriate and necessary to provide the guidance. Including if it's necessary for the GEF to reserve some funds for the future implementation of the agreement. Therefore, China supports in principle the practice for the PrepCom to provide a temporary guidance for the replenishment of GEF. China also hopes that the co-chairs will give guidance in terms of what kind of opinion can the PrepCom provide for the replenishment of GEF, including if the co-chair is going to provide some documents for parties to discuss. Thank you.
I thank the distinguished representative of China. Before we conclude this item, delegates, we've just sought in relation to the question asked by the distinguished representative of Brazil as to possible modalities for communication. We've had consultations with Dualos and also informally with the GEF. And the advice is as follows. This could be transmitted through reflection of what the Preparatory Commission agrees in the co-chair's closing statement. The co-chairs could then send a letter to GEF CEO transmitting the outcomes of the Preparatory Commission's consideration of this item. So with that, delegates, I would propose to conclude. Oh, Brazil has requested to take the floor. Brazil, the floor is yours.
Thank you very much, Co-Chair, and I don't want to be in the way of us closing this segment, but of course, thank you very much for providing us with more clarity on the process to engage with the GEF 9th replenishment process. We do have some follow-up questions. So as you just outlined, one of the key issues of confusion we were having was on the use of terminology guidance. So as far as I understand from your explanation, the PrepCom would not be providing guidance to the GEF 9, but actually reflections on specific elements that the membership identified as important to that process. So if we can have clarity on if this is the correct understanding. A second follow-up question would be, this reflection would be captured by the co-chair's closed statement of PrepCom 2, as far as I understood. But this statement is not to be negotiated. And as far as we understood, there are still pending issues or non-consensual elements. So we would like to see also clarity on how to guarantee that we will have a balanced approach if we do go into that possibility of providing reflections to the JEF in their replenishment process. We would be ready to discuss those elements and provide inputs, but should any element that we don't agree to be reflected in your closing statement, how can we then course correct things before the letter would be sent to the JEF CEO? Thank you.
I give the floor to Palau. Sorry, I've got two speaking lists in front of me with different regional coordinators. So Palau speaking on behalf of AOSIS. Palau, the floor is yours.
Thank you very much, Mr. Co-Chair. So I think similarly in line with probably some of the questions that were provided by Brazil on behalf of CLAM is to just get clarity on when we would engage in discussions on finalizing this agreed set of recommendations from the preparatory committee, noting as well and would align with the kind of the legalistic view of CLAM that we would for sure want to stay away from the concept and the term of guidance given its importance and relevance in the treaty itself. But it would be good to understand when it would be done, especially noting that, and we highlighted this in our intervention on other matters related to the financial mechanism, is that we would like to have adequate time to discuss the operationalization process for the special fund as well, noting that I think even reflecting on the information note from the Secretariat, what more can we say beyond what is in that programming direction that has already been highlighted from the Secretariat in great detail? So we would seek clarity as well as to make sure that we balance adequately the time that we are spending on the various different entities that make up our financial mechanism, noting that we have a lot of work to do in the context of the special fund. Thanks a lot, Co-Chair.
I thank the distinguished representative of Palau speaking on behalf of AOSIS. If delegates will just give me 20 seconds to confer with my fellow co-chair. Thank you, delegates, and I thank you for your patience. A couple of points on this item. The distinguished representative of Brazil has, of course, noted quite correctly that the co-chair's closing statement is not negotiated. However, the points on this item to be included in the closing statement could, of course, be negotiated prior to being included, either on the floor or perhaps more efficiently through the Bureau, where all regional groups are represented. And I would note that the distinguished representative of Brazil indeed sits on the Bureau. The second point I would note is advice we have received from the GEF on an in inverted commas guidance. It would be provisional guidance communicated to the GEF Secretariat akin to comments that the GEF receives from other entities. For example, comments from multilateral environment agreements that the GEF does not formally support. So that is advice provided in real time from the GEF for information. So I think at this stage, this is about as far as we can take this. There seems to be general support for the idea that some advice be provided, and I heard that from several delegations, certainly in terms of the points legitimately, very legitimately raised by Brazil and also Palau speaking on behalf of AOSIS. There would obviously be no intention on behalf of the co-chairs that anything be forwarded that was not clearly the consensus advice of this preparatory commission, and perhaps we can pursue that in the first instance through the modality of the Bureau without changing the fact that the co-chair's statement overall is not a negotiated document, but we will ensure that this part of the co-chair's statement most definitely reflects the consensus advice of the preparatory commission. With that, I would propose to close this item unless anyone else wants to take the floor. Palau has requested to take the floor. Palau, speaking on behalf of AOSIS, you have the floor.
Thanks a lot, Mr. Co-Chair, and not to belabor the point, but I think there was one part of the intervention that you didn't address, which was specifically the fact that we're discussing a matter here under other matters, right? Which was brought up, I assume, by request of some of the parties here in the room, but noting that we have matters that are outstanding under Cluster 3 that specifically refer to the operationalization of the financial mechanism. There hasn't as yet been kind of an understanding of will there be time to also discuss and ventilate those views in the context of that, specifically with the special fund, but it is kind of implied a bit that the discussions on other matters, discussion on the GEF 9 replenishment will be given time to have a potential negotiated outcome under guidance. And so I think clarity from our end is on how are we making sure as well we're going to give adequate time to the special fund matter, which is a part of the clear mandate of the PrepCom to deal with. Noting again, the treaty is very clear on the shared mandate that the GEF fund have, and they have the guidance from us as parties, us as persons who engaged in negotiating the BBNJ agreement. So I think that at least at a minimum, they have that to fall back on. Thanks a lot.
Thank you very much, Palau, for your comments. And just to flag that at the first session of the Preparatory Commission, we did discuss the issue of the GEF 9 replenishment, and it was in our closing statement noted that this would be something taken up in PC2. It was also consulted with the Bureau, and I trust that that information was transmitted. In respect of the issues regarding operationalization of other provisions on financial resources and this in regards to the special fund, next week, there are two scheduled meetings on those, on that matter. And it would just be noted that the Bureau was consulted on a potential way of addressing some of the issues that were raised during our first round of discussions on these operationalization of other provisions of financial resources. And we do intend to take that up, and you will be, all delegations will be notified on how we proceed thereafter. So point well taken, and we are going to cover this fully and evenly. Thank you.
Thank you very much, delegations, and that concludes consideration of this item for now. With the 15 minutes we have left, we would like to resume consideration of yesterday's discussion on the rules of procedure. I appreciate that we will, of course, not complete that discussion. However, if we can manage to hear a number of the further inscribed speakers, that then means that it is possible this afternoon, depending on what time we have available, that we might be able to complete that list. I see that the Russian Federation wishes to take the floor, but in terms of my speaking list from last night, I had Argentina first and then the Russian Federation. So I'll give the floor to Argentina to be followed by the Russian Federation. Argentina, you have the floor.
Muchas gracias, señor presidente. Muchas gracias.
Thank you very much, Co-Chair. We're going to make these comments in our national capacity, in addition to the ones that we made with CLAM on previous days. We'd like to make this statement in our national capacity to refer to Chapter 3 of the document AAC 296 2025/12 that regulates everything to do with the participation of observers in the proposed rules of procedure of the Conference of the Parties. In this regard, it must be underscored that Argentina supports the participation of observers in line with the provisions of the agreement in Article 48. Said Article 48 establishes that the Conference of the Parties and its subsidiary bodies shall establish the modalities for the participation of non-state entities that wish to participate as observers. On a preliminary basis, it must be recalled that Argentina submitted written comments in our national capacity on this matter during the intersessional period, pursuant to the requirement of the co-chairs. In this regard, Argentina wishes to reiterate that we understand, as other delegations have expressed on previous days, such as the African Group and China, that a mechanism needs to be included that preserves as the final requisite the criteria of non-objection of member states, that guarantees the need for consensus. We see that the non-objection rule has not been included in this new version of the document. Based on this, we wish to propose as an alternative that we take up the text of the last UN Oceans Conference, whose rules and modalities were adopted in December 2023 by way of document A/Res/78/128, and that distinguishes between organizations that have an advisory status to ECOSOC and those that do not, those to whom a non-objection procedure is applied, and we can present a text in this regard. Another alternative that we could support would be in the proposal that we heard in the room that was made by the delegation of China on the rules for the participation of observers for the United Nations Conference Against Transnational Organized Crime, that distinguishes between the different categories of observers, providing detail on the way in which each of them may participate. Mr. Co-Chair, reiterating once again how important it is to adopt modalities that preserve the criteria of non-objection from states parties, Argentina expresses the fact that we stand ready to reach in the future an adequate text on these rules. Thank you very much.
Muchas gracias, Argentina. I will now give the floor to Russia, to be followed by Singapore and then Canada. Russia, you have the floor.
Thank you very much, Mr. Co-Chair. I'm going to be speaking on several aspects of the rules of procedures. For Rule 3, we think it is sufficient for the conference to hold meetings at the seat of the Secretariat and at its headquarters if no new decision is made. Rule 3 bis is not necessary at this juncture because it's not a UN practice, or to be more precise, such a thing doesn't exist in the rules of procedure of the UN General Assembly. And so this would place on unequal footing the states, that is, those who lack technical capacity to participate will be prevented from participating. So in that case, if there's a force majeure circumstance like was the case under the COVID-19 pandemic, then a decision will be taken by the Secretary General. Next, as for observers, that's section 3. Section 3 needs to be deleted and it should be put into section 10. On the holding of meetings. To meetings, all UN member states should be invited. Members of the specialized bodies of the United Nations, the parties to the Convention on the Law of the Sea, have the right to participate in the conference. And as observers, but the invitation of other subjects is not stipulated under the UN Charter. And under the UN Charter, it's the prerogative of ECOSOC to take requisite measures for consultation with NGOs. In that regard, this would not be a prerogative. So we need to observe the Charter of the United Nations. That's Article 71. So people can organizations can participate if they have the requisite status, but otherwise, no. Next, the most important is the decision-making process. That is section 10. So the decisions of the conference should be taken by consensus, because this bears on the interests of absolutely all UN member states, and the Convention on the Law of the Sea is universal in nature. And the human rights that are concerned here are very important, including the fact that the agreement has stipulated unusual forms, such as area-based management tools, which certainly would fall under the purview of already existing organizations. In that regard, all decisions must be taken by consensus on substantive matters. If there's any doubt of whether or not this is a substantive matter or a procedural matter, then it will be deemed to be a substantive matter. As for procedural questions, they can be resolved by a vote, following the rule that every state party to the agreement has one vote, just to ensure that that doesn't diverge from the rules in the rules of procedure of the General Assembly. And all of the UN bodies operate under that rule, which follows the fundamental principle of international law, which underpins all international relations. I'm referring to the rule of the sovereign right of states, which is written into the Charter in Article 1. So no international organization has the right to participate in the voting. And Article 103 of the UN Charter clearly says that if the obligations of a member state under the organization, under this charter, is in conflict with any other international agreement, then preference shall be given to the obligations of the charter. That says it all. Thank you.
I thank the distinguished representative of the Russian Federation. Delegates, we're just trying to see if we can get an additional 5 minutes worth of interpretation. On that basis, I will give the floor to Singapore and then at least to Canada and hopefully Chile. Singapore, you have the floor.
Thank you very much, Mr. Co-Chair. And thank you for also very helpfully clarifying the usage of the terms budgetary and financial at the start of last afternoon's meeting, which Singapore had raised in relation to Rule 15. With that clarification that they refer to two distinct matters, we are comfortable with Rule 15 as drafted. Turning to the guiding question 3, I just have 2 comments. And the first would be on draft Rule 3 bis, in-person and or virtual participation. Like many in the room, Singapore agrees that the ROP should enable virtual participation, and we support the general rule that COP meetings should be held in person unless extraordinary circumstances render the holding of in-person meetings impracticable. And in that, I use the term that was proposed by the UK last afternoon, which we think is a good refinement and certainly expresses a higher threshold than impractical. And we consider that this would be a better approach than trying to define exhaustively extraordinary circumstances. However, like many others, including CLAM in Australia, we agree that draft Rule 3 bis can certainly be streamlined. And since we're moving on to a refreshed text, we will provide some concrete streamlining suggestions. First, we consider that many of the matters in paragraphs 7 to 10 may not need to be included in the ROP and could instead be included in a guidance document on virtual meetings, which could be adopted by the COP at a later stage. I think that would also save us the trouble of debating the preferred duration of virtual meetings and allow us to focus our attention on other more pressing issues given the impending entry into force. In addition, we agree with CLAM that paragraph 3 could benefit from clearer drafting. First, there could be greater clarity as to what amounts to urgent decisions, which may be taken by the COP under a silence procedure. And I note that this appears to be different from urgent and important decisions, which Mr. Co-Chair had kindly explained and clarified for us in relation to Rule 13 last afternoon. And second, we, like CLAM, are not quite sure how to pass the phrase, quote, and a decision of the Bureau of the Conference of Parties, end quote, and whether the sentence, if this sentence is intended to mean that the silence procedure may be activated following a decision by the Bureau of the Conference of Parties, then we think that some redrafting is necessary to more clearly express that. And we are happy to work with others on efforts to streamline this provision on the basis of the refreshed text. Moving on to my second point, which is on draft Rule 60 on amending the rules of procedure. We support option 2. Under Article 47.4 of the BBNJ agreement, the ROP shall be adopted by consensus at its first meeting. So we therefore think it would be incongruous if the ROP could then be amended by a 2/3 majority or simple majority of parties, which is what is contained in option 1. We prefer option 2, which is for the ROP to be amended by consensus. And we note that this is what the CBD and UNFCCC also provide for in their ROPs. However, in line with Article 47.5 of the BBNJ agreement, we consider that going into a vote, if efforts at achieving consensus have been exhausted, would be appropriate. And this is indeed what is provided for under Rule 45 of the Rules of Procedure. And we are therefore supportive of the proposal which was first raised by AOSIS in relation to Rule 60, which is, quote, the present rules of procedure may be amended after the Bureau has reported on the proposed amendment by a decision of the Conference of the Parties adopted in accordance with Rule 45, such decision being on a question of substance. Singapore's view is that the amendment of the ROP is a decision on substance for which the higher voting threshold of a 2/3 majority should apply. And we agree that it's not necessary to refer again to the 2/3 majority of parties participating in the meeting for the reasons cited by the PSIDs. Thank you very much, Mr. Co-Chair.
I thank Singapore and provide the welcome news that we have indeed secured an additional 5 minutes of interpretation. I will pass the floor to the distinguished representative of Canada, who I'm sure noted the outstanding example set by my good friend, the distinguished representative of Turkey last night in finishing at 5:59 and 45 seconds precisely. Canada, the floor is yours.
Thank you, Co-Chair. At the same time, I'm also cognizant of not overburdening interpreters in terms of the speed at which I will read our input. It has been Canada's position since the beginning of the first session of the Preparatory Commission that the rules of the procedure for the COP should be fairly simple, flexible, and adaptable. And having heard various proposals made throughout the week, and considering that the adoption of the rules of procedure and their amendment is likely to be by consensus or high threshold otherwise, it would be prudent to avoid adopting rules that are rigid or highly restrictive. Instead, they need to be enabling, facilitative, inclusive, and conducive to effective governance and operation of the institutions established under the agreement. As such, Canada proposes making the following changes to the revised aid to discussions. First, remove paragraph 9 in Rule 3 bis, given that if online sessions of the COP are only to be held in unforeseen circumstances or exceptional cases, such as the global pandemics, or to advance discussions on matters such as emergency measures, then limiting the duration of such sessions appears a bit too prescriptive, could be impractical and prohibitive, as we cannot foresee what would be the appropriate length of online sessions. Next, in Rule 11, regarding the distribution of provisional agenda, of course, we would be interested in learning and getting maybe some clarity in terms of what are the current practices when it comes to distribution of agenda. But to us, it appears that it would be better to add observers to follow parties in line 3, to make provisional agendas available, not just being available, but actually circulated to observers who are already registered and accredited, and to make provisional agendas available to general public. So we would appreciate clarification from Wallace on the current approach and practices in that regard. Next, we would like to ensure that Indigenous peoples can participate meaningfully in the meetings of the COP and subsidiary bodies. And in that regard, Canada fully supports the proposal that was submitted by PCIDS, more specifically to add new paragraph 2 bis in draft Rule 7, which would read as follows: participation by Indigenous peoples and their organizations in all proceedings of the Conference of the Parties and of its subsidiary bodies shall be in accordance with the United Nations Declaration on the Rights of Indigenous Peoples, and also to remove the qualifier of with relevant traditional knowledge from the current paragraph 1 in draft Rule 7. Next, we would propose removing paragraph 2 bis and Rule 22 and paragraph 2 in Rule 28 bis, which are unnecessarily punitive as opposed to being facilitative. In general, rules of procedure should be encouraging broad participation. They should support parties when they face financial difficulties, especially when they're caused by phenomena outside of their control. Furthermore, similar draft rules are also reflected in the revised aid on the draft financial rules, which are already misaligned and do not correspond to these paragraphs in draft rules 22 and 28 bis. So if not removed, then we would propose that they are fully bracketed. And finally, we agree with observations made by PCIDS yesterday in regard to the need to carefully approach the draft Rule 30 bis. The current formulation seems already a bit awkwardly phrased and might be too rigid and stifling. So subsidiary bodies should be able to consult with each other freely without the approval or direction of the COP. So we would suggest either fully bracketing for further discussion, or just would appreciate further consideration from other delegations. Thank you, Co-Chair.
I thank the distinguished representative of Canada greatly for his intervention and his flexibility. And in fact, on that note, I think I would like to express the gratitude of both of us as co-chairs for the flexibility of all delegations in dealing with a moving agenda this morning, reflecting the desire of many delegations to ensure that rules of procedure are considered under interpretation, reflecting obviously the strictures under which we are operating in terms of maximising the use of the conference facilities, and also our need to conclude this item in order that we can produce over the weekend the refreshed version of the rules of procedure that is so desired by so many delegations. At this stage, we only have 4 speakers left: Chile, the Philippines, Iran, and Oman. I will ask the IWC and the High Seas Alliance if they would be gracious enough to provide their interventions in writing, so that hopefully we can conclude this item in this room reasonably quickly in the afternoon session. And with that, I now give the chair to the Secretary.
Thank you, Mr. Co-Chair. This is the usual announcement on side events. There is only one side event today, which will take place in this conference room. It is entitled Taking a Wider View from Sites to Networks for BBNJ, and this is organized by the Global Ocean Biodiversity Initiative, the German Federal Ministry for the Environment, Climate Action, Nature Conservation and Nuclear Safety, and the International Union for Conservation of Nature. Thank you.
Thank you all delegations. We will have a great lunch and we'll see you in the afternoon.
Good afternoon, everybody. We just need 5 minutes to sort out our slides and technology, so please relax, but we'll be with you shortly.
you.